Good afternoon. You're listening to Community Radio Iman FM at 103.FM. The studio hotline number is 0114 24 25 200. WhatsApp number is 07 88 55 99 786. That's 07 88 55 99 786. My name is Shahid Hussain. I'm with Khan Solicitors, and we are happy to bring this 1 hour slot to you, discussing various aspects of immigration law. If you were tuned in last week, you would have recalled the conversation we were having about people's right to enter the UK and which category of people was subjected to immigration rules and regulations. This week we're going to be touching on European Union law and the possible changes that are going to take place as a result of the events that have taken place in this week just gone. If you've been watching the news, you'll have noticed that Theresa May has been in the headlines because we as a nation, through the Prime Minister, have triggered the Article 50. Now you might be wondering what that is, what's that all about? And today we're going to talk about that, as well as some of the implications of it. But before we get into that, what I need to do is discuss how European law actually affects people on a day-to-day basis. Last week we talked about people who had no right of abode and were non-EU nationals and who were subjected to UK immigration rules as set out in Section 1 of the Immigration Act 1971. We didn't talk about EEA nationals and how they are affected in detail. To understand this category, we need to understand how the UK ended up with an obligation to European citizens. In effect, when the EU was formed and the UK entered the EU as a member state, it entered itself into an obligation, and that obligation was enacted into UK law through the European Communities Act in 1972. That legislated the accession of the UK to be part of the EU. And part of that commitment was that it would allow citizens the right to freely move into the UK and vice versa. EEA nationals throughout the EU have been designated as part of that commitment to being a member state as being citizens of the EU as well as citizens of their own country. And what that means is defined in Article 20 of the Treaty on the Functioning of the European Union. It established that every individual citizens of the member states of the European Union had been given citizenships of the Union itself, of the European Union. Those people that were afforded that right of citizenship were then given the right to move and the right to reside within the territories of the member states. Give them rights to vote and stand as candidates in the European Parliament. Give them right to move freely and establish employment and work throughout the European Union. Many people have exercised that right. Many people are living in the UK as members of the European Union from different parts of the Union, different countries, and they have a right to be here and they have the right to exercise their right. They're going to be asking the question, how is it going to affect us now that the UK has triggered Article 50? The three areas of rights of admission to people who are EEA nationals are as follows. They're defined in the Immigration Regulations 2016. The first is the right of them to be admitted into the country They have a right to be admitted into the country, as do their family members. Secondly, they have a right of residence. So once they've entered the UK, they have a right to reside here. Initially, that residence period is permitted for 3 months, but beyond that, if you've been here 3 months, you need to have established yourself as a qualified person. Once you've established yourself as a qualified person, yourself and your family member can remain in the UK for beyond 3 months. People who have been exercising this right to enter the UK, to live in the UK, are asking themselves a question. Is that going to change? Are we going to be required to leave? Let's talk about a qualified person. A qualified person is defined in Regulation 6 as a person of one of the 5 categories. It can be a person who's a job seeker. So somebody from one of the EEA national countries coming to the UK looking for a job, looking for employment. They need to establish that they're seeking employment and it's a genuine search and they have a genuine chance of getting employment. We've seen many people coming into UK from Europe looking for jobs and fulfilling roles within the employment sector, providing their talents and abilities to do jobs that they've either got previous experience for or they have developed the experience while they're in the UK. But in either case, they are, by law, allowed to come here as job seekers. Second category is the worker or the employee. A person is allowed to remain in the UK as a qualified person if they are an employee of a business, of a company, and they are exercising their right as a qualified person by simply being an employee here. Third category of person that is allowed to come to the UK as a qualified person and remain here beyond 3 months is somebody who's self-employed. They've got a business that they're running. They might even be employing other people. When you're driving around Sheffield and you're driving around different parts of the UK, you'll notice, or you will have noticed, many people from European backgrounds having set up many businesses with different flags and signs and languages being used which indicate that they have a European slant to them. So somebody who's self-employed running a business is entitled to be in the UK as a qualified person. The next category of person is a person who's self-sufficient, somebody who's got enough funds for themselves in that they don't need to seek access to public funds. They've got enough money saved up, they've got enough money to pay for their own selves, and they fall into that category of a qualified person. The last category is the category of a student. A person who's a student, generally coming here to study different types of courses. They can come here to the UK and they would be under the category of a qualified person. Now, that covers a lot of people, right? A lot of people fall into those different types of categories. You might be listening to this show and thinking, well, I'm one of those people. I identify myself as a person who's come from the European Union and I'm exercising my right as that. And now, given that the UK has triggered the Article 50 and there's moves being made to leave the EU, how's that going to affect me? Am I going to be allowed to continue to stay here? Do I need to make arrangements to formalise my stay here? What's going to happen? Some of you will be listening and you won't even know what Article 50 is. You'll be wondering, what's it all about? What has the government signed? Well, Article 50, when we talk about article, we're referring to a part of the treaty that the UK government signed, part of the Lisbon Treaty. And what that does is that it actually formalised the mechanism in which any European Union country can leave the EU. Now, this happen in 2007, but prior to 2007, there was no mechanism for any country to leave the EU. There's no formal way that if a country wanted to leave the EU, they could leave. So in 2007, the member states decided to put that into place to reflect the democratic nature of the union, and it became law in 2009. And the UK is the first country to actually make a decision and to implement a decision to actually leave the EU. And it officially was triggered on the 20th of March of this year, right? Around 12:30, just before 12:30, our British Prime Minister indicated that we were triggering Article 50 to leave the UK. Now, not only does this article give the right to a country to leave, it also describes the mechanism in which the country can leave, and it gives them a timescale. That timescale is 2 years. So we're looking at April 2019 as the time that the UK is going to be given to make its proposals, to negotiate with the EU about what needs to be settled between the member states and the UK. There is a possibility that that time could be extended, but there is a lot of pressure on both sides to have this done and dusted. So although we've triggered, the Prime Minister's triggered the Article 50 for us to exit the EU, we've still got about 2 years for it to become a reality. So when you're thinking about how European law is going to become absent from UK law, you're looking at a timescale of 2 years. And in that 2 years, hopefully we've all got plenty of time to sort out any outstanding matters that we have with respect to immigration status, with respect to formalizing things. Some people are married and they have a spouse that's from the European Union community, and they're here as a spouse or a civil partner. Regulation 7 is what allows people to bring in family members from the EEA. If you're a EEA national and you've got a family that's not necessarily from Europe, you can still bring them in, provided that they're your spouse or civil partner, or they're your direct descendants under the age of 21, and they're dependent on you. So those category of people are also wondering, what's going to happen? Are we going to be affected? Are we going to be asked to leave? If you've got these questions in your head, please share your thoughts with us. The WhatsApp number is 07 88 55 99786, and you're listening to Iman FM 103.FM, sponsored by Council Listers today in this hour. Sponsored by Council Listers to give you a chance to think about and discuss some of these issues that are affecting everyone. Free movement of workers is defined in Article 45. And what it says is that people who are coming here with an offer of work or for the purposes of finding work can stay in the member state for the purpose of employment, and also they can actually stay after their employment's completed. Article 49, as we pointed out earlier, allows people that are self-employed to remain in the UK for the purposes of running their business or establishing a business. Article 56 and 57 requires, and this has been implemented already, member states to remove any restrictions that would prevent people from exercising those rights. Now, if these requirements have been placed on the UK government, and the UK government now has decided to take itself out of the European Union, how is it going to affect people who are here with employment, people here who are running businesses? How is it going to affect different types of people? If it is something that you've got on your mind, you're concerned about, please message us on WhatsApp. Our number is 0788855998786. There are different types of institutions in the European Union, including the European Parliament, that's been responsible for legislating laws, that's been incorporated by all the member states to some degree or another. There's also the European Court of Justice that has allowed people to appeal different matters when they felt that their own member state has not been able to deal with their grievances. Obviously, in the long run, that won't be an option for people if, in fact, we have withdrawn from the European Union. Many legal cases, you may have seen in the news, have gone all the way to the European courts and people have had matters settled there. Now, the question you're probably asking yourself is, what's going to be the option for us after that's been removed? These are really important questions, because some of these cases that have gone up to European Court have been quite instrumental in defining what the rights and regulations are of people with respect to immigration law. And if that's taken away, what recourse would people have other than the internal courts within the UK? As I've said, you have at least 2 years to think about your situation, think about your circumstances, and consider investigating whether you need to formalise your stay, if in fact that's something you intend to do for a long term. If you intend to settle and remain in the UK, you need to consider the possibility of formalising your stay after we've formally left the EU by April 2019. If you're a British national and you've married somebody from the European Union, you might be wondering to yourself, what do I need to do to formalise my partner's stay in the UK? Well, generally speaking, European nationals are privileged in the sense that they can be taken as having established their leave to remain if they've stayed in the UK during a period that they qualify to stay, and 5 years have passed. After that point, they're entitled to make further applications to formalise their settlement. If you are a non-EEA national and you've married a person who is an EEA national, then you certainly need to consider what steps you need to take to formalise your stay. For those of you that don't know, the European law has provided significant advantages to European nationals over and above UK nationals. We touched upon this last week. For example, a person who is a British national wanting to marry somebody who is a non-EEA national has to meet the requirements of the UK immigration law, which for many people is tough, right? The financial requirements in itself pose a great obstacle for people who are on low income. But conversely, if you're an EA national and you're living in the UK and you happen to have married somebody outside of the European Union, you can bring that person into the UK without actually needing to meet the requirements of UK immigration law. Many people saw that as unfair. Many people saw that as unjust to British nationals, and I can see why that would be the case. I can see why people would consider that to be unfair to people who are living in the UK, having to fulfill requirements that people in the EA nationals are not required to fulfill. In addition to that, not only can EA nationals bring in people who are spouse or civil partners, they also have the option, continue to have the option until we actually formally leave, to bring people who are direct descendants. And there's actually a very wide scope of people that fall into the category of direct descendants, including children and grandchildren. But generally speaking, they need to be under 21 and they need to be dependents. So if you take the case of somebody who is from a European Union country, they're living in the UK and they have a relative who's a dependent under the age of 21, a child or a grandchild who's not an EA national, that EA national is entitled to bring them into the UK and circumvent the requirements normally of UK law. As for a spouse and a partner, where you would normally be expected under UK immigration law to fulfill all the requirements, as an EA national, as long as the person is the spouse, civil partner, either accompanying them into the UK or intending to join them in the UK, they can sidestep the requirements of immigration law. People have described that as a loophole, and some British nationals have actually utilised that as a loophole when they were unable to meet the immigration rules themselves. I think perhaps some people have considered that one of the reasons why they felt that it was necessary to leave the European Union, because of disparities in laws which they felt were not being fair to British nationals. What are your thoughts? Have you been affected by that? Are you a British national who's not been able to bring in their spouse because of the strict requirements of immigration rules? Are you somebody who's tried to bring in somebody and failed because of these rules, and you've noticed that other people have managed to bring in their spouses and civil partners without having to meet those rules? Let me know what you think. We're going to take a short break, take our number down and give us a call. We'll see you after the break.
Locally at 103.1 on FM. Globally at imanfm.com on the internet. This is Iman FM.
आपकी खातिर सजा है शेरो नगमा का चमन, आप ही के दम से है आबाद ये बज़्म सुखन। जी हाँ, प्रोग्राम है बज़्म सुखन। मैं हूँ आपकी होस्ट कौसर शाह। ये प्रोग्राम आप सुन पाते हैं एवरी वेडनेसडे 11:30 से लेकर 1:30 बजे तक। प्रोग्राम में शेरो अदब के हवाले से बात होती है, आप भी शामिल हो सकते हैं, सो सुनना ना भूलिएगा।
Khan Solicitors, experienced criminal defence lawyers in defending your rights. We can assist you get the best possible outcome if you're involved in any criminal matters, including murder, drug offences, sexual offences including grooming, terrorism, fraud and money laundering. We can provide free advice and assistance 24/7 at the police station. Call us on 0114 258 3399 at 351 Abbeydale Road, Sheffield. Visit us at khansolicitors.com. Over 20 years experience in defending your rights.
अरे शमसुद्दीन भाई, यहाँ कहाँ घूम रहे हैं?
भैया रोडरम में कोई खाने का अच्छा जगह होगा है?
रोडरम में उम्दा और लजीज खानों का वाहिद मरकज, चौधरीज ओरिएंट एक्सप्रेस।
अरे भैया तो टाइम जाया ना करो, जल्दी करो, भूख लग रहा है।
देर न लाओ, आज ही आओ ते फायदा उठाओ।
Cater to impress, चौधरीज ओरिएंट एक्सप्रेस, Princess Street, Rotherham, telephone 01709 555527।
हर कोई सज्जन मित्र बोले, चौधरीज ओरिएंट दे पैगे रोले, कुकड़ पाए दे गोश्त कढ़ाई, आके खाओ होले होले।
Aziz Catering, the award-winning caterers specialising in weddings, engagement, birthdays, business parties or any other special occasion from 30 to 5,000 people and delivered anywhere in the UK. All starters, main course and desserts freshly cooked to order and you're welcome to taste before you order. Aziz Catering, 1 Whitefield Place, Bradford, BD8 9JB. Call 01274 488874. Aziz Catering, once tried, never forgotten.
At iLet4U, we know that being a landlord can be a frustrating business, but it doesn't have to be. iLet4U can find you tenants in under a week. iLet4U, specialist in selective licensed properties.
अगर आप मकान किराए पे लगाना चाहते हैं तो हमारी खिदमत हासिल करें और घर बैठे किराया पाएं। iLet4U पर हम आपके घर को अपना घर समझकर रेंट पे देते हैं।
Start finding tenants today by contacting iLet4U, 60 Page Hall Road, Sheffield, 0114 327 2020.
मुअज़्ज़म अली शहीद वेलफेयर ट्रस्ट के ज़ेरे एहतमाम जेएलएम में कायम अस्पताल में पिछले 18 सालों से इलाज मुआलजा मुस्तहिक अफराद को फी सबिलिल्लाह फराहम कर रहा है गरीब खानदानों और यतीम बच्चों के लिए माली इमदाद दी जाती है
With your help we can save lives, educate and help reduce poverty.
आप अपनी ज़कात सदका और खैरात ट्रस्ट को देकर इस कार खैर में अपना हिस्सा डालें
For more info call on 0779 251 5561 or visit muslimtrust.org.uk.
إعلان عاجل لسائقي سيارات الأجرة وسيارات الأجرة الخاصة وسيارات هاكني كاريج مستر كومبنسيتر يدفع 2000 جنيه كتعويض لطالبي التعويض لسيارات الأجرة سيارات البرستيج وسيارات الدفع الرباعي بسبب الحوادث التعويض مضمون بنسبة 100% خدمتنا متوفرة طيلة 24 ساعة على 7 أيام اتصل بنا الآن على الهاتف رقم 0114-386-3386 التعويضات تنطبق على سيارات الأجرة فقط كل ذلك وفقا للشروط والأحكام
Online at www.imanfm.com and on our app, you're listening to Iman FM.
Welcome back. This is Shahid from Khan Solicitors and you're tuned into Iman FM 103.1 FM. The studio number is 0114 24 25200. We also have a WhatsApp number 07885599786. You're with me for this hour discussing immigration law, and in particular we're talking about one of the most historic events in UK immigration law history, and that is the decision of the UK government to implement the decision of the referendum of the British people to withdraw from the European Union. 29th of March 2017 was the key date that our Prime Minister wrote to the President Turk of the European Union and told them that the United Kingdom Parliament confirmed the result of the referendum to withdraw from the European Union. The bill was passed on 13th of March and received royal assent from Her Majesty the Queen and became an Act of Parliament on the 16th of March. Our Prime Minister wrote and stated as follows: I hereby notify the European Council in accordance with Article 50 of the Treaty on European Union of the United Kingdom intention to withdraw from the European Union. This is the first country to actually exercise this right under Article 50 to withdraw from the European Union. And many people have been affected directly or indirectly by this decision. Like I've said before we went to the break, that although the article has been triggered this month gone, the article itself provides 2 years for the member state that's leaving to negotiate with the European Union to make arrangements for itself to formally leave. And many people are asking the question, how is that going to affect their lives if they are in fact EA nationals living in the UK exercising a right, or they have family members that are EA nationals, or in fact they are not EA nationals but they are family members of EA nationals living in the UK. How does that affect them? We also touched upon the difference between European nationals and people who have a right of abode, and people who are non-EA nationals are subjected to immigration rules. And the distinction I pointed out was that the people who fell under the category of EA nationals had the following three rights. The first right that they have is that they have a right of admission to the UK, and so do their family members. The family members need to be either travelling to the UK with the EA national, or they are travelling independently but with the intention of joining the EA national family members. So normally where you are not a British national and you're coming into the UK, you'd be subjected to immigration rules and regulations, right? You'd have to have a visa in place, you'd have to like we talked about last week, you'd have to fulfill the requirements of immigration rules to gain permission to enter the UK. But if you are a family member of an EA national, their right is that they're entitled to have you join them. The second right an EA national has under the Immigration European Economic Area Regulations 2016 is the right of residence. So not only are they allowed to come into the UK, but they're also allowed to live here, right of residence, for initially up to 3 months. So they can come into the UK and live here for 3 months, and beyond those 3 months they can continue to stay here if they fulfill the criteria of a qualified person. Either they are a qualified person or they are a family member of a qualified person. Now, before we went to the break, I touched upon the 5 categories of a qualified person under Regulation 6. They are as follows. Number 1, person who's come here to look for a job. Person who's a member of a European Union member state, has come here to look for work. They're entitled as a qualified person to stay here even beyond 3 months, so long as what they're doing is searching for a job and that's genuine. Second category we talked about was the person who's an employee. Somebody who's here and has got a job and they're working legitimately. They're classified as a qualified person. Third category we said was a person who is self-employed. They've come to this country and they are running a business and they're self-employed. They're classified as a qualified person. Fourth category of person is a person who is self-sufficient. Somebody who's got enough money to pay for themselves and not burden on the public assistance. They're entitled to be a qualified person and remain in the UK beyond 3 months. Fifth category is a category of student. Somebody who's come from the EA countries and is here as a student. They're allowed to remain here in the UK. And these privileges also extend to family members. And we discussed this before we went to the break, that family members of EA nationals are defined in Regulation 7. The first category is the obvious one. A person who's a spouse or a civil partner of an EA national exercising their right to be in the UK under European law. Second category is direct descendants, which generally includes children or grandchildren who are under 21 and dependent on the EA national and their spouse. We've seen many cases of this, that people have been living in the UK as EA nationals and they're actually married to people who are not British nationals and they're not EA nationals, but they have been entitled to remain in the UK as a direct family member. Does that fulfill the requirements? It certainly does. You can call us on the studio hotline 0114 2425 200. You can WhatsApp us on 07885 99 786 at Iman FM 103.1 FM, and this program is being brought to you by Khan Solicitors. I also discussed with you before the break that the UK has taken a decision to exit the UK, follow the referendum that took place. Maybe you voted in that referendum. What's your thoughts? Did you vote to leave? Did you vote to remain? There was certainly some protests that took place in London just this week gone about people who were adamant that we should have stayed in the European Union, and they expressed their views in a protest in London this week gone. But the Prime Minister did trigger the Article 50, which I mentioned before the break, is part of the Lisbon Treaty, giving the rights of any EU country to leave the UK. And I also mentioned before the break that the United Kingdom is the only country that has actually taken the decision to leave the European Union. And I have no doubt that this is going to affect a large number of people that are either exercising their rights as EEA nationals or they are family members of EEA nationals exercising their rights. If you fall into one of those categories, please give us a call, give us a message and let us know what you think, whether it's affecting you or not. People often ask us the question, and people often panic that March the 20th seems to be in their mind a cut-off point. Well, like I've said earlier, it is not the cut-off point. It's simply the United Kingdom's indication to the European, using the Article 50 of the Lisbon Treaty, that we are formally making a decision to leave. And if you want to know the time scale that we're looking at, it's at least until 2019, April 2019. This can be extended, but as it stands, the default timescale is 2019. And so I'd urge you that if you fall into any of these categories, you need to seek the necessary legal advice to discuss your status, formalize your stay, if you're an EA national, and also if you're a family member, you can also look at how to formalize your stay in the UK if you're a non-EA national. Some people have come here as family members of EA nationals, and sometimes the relationship breaks down. Well, all is not lost. In some cases, just because the relationship has broken down, or perhaps even very tragically, the EA national that you've been married to as a non-EA national, the person has passed away, does not necessarily mean that you need to leave the country. Again, this is something that you need to seek legal advice about, and there are options available to people who fall into that category to look at ways of formalizing their stay under the rules and regulations. Now, some people naively think that because Regulation 7 allows you to remain in this country as a spouse, they can simply get married to a person who's an EA national, and that's it. That would allow them to stay in the country. Well, stating the obvious, the marriage, civil partnership, has to be a genuine one, right? And when an application is submitted, when evidence is submitted for this purpose, you have to be aware that the evidence is examined quite rigorously. And there has to be a very clear indication that those people who are married have done so genuinely. It's not simply the case that if you put forward a claim that you're married and therefore you're entitled to remain in the UK as a non-EA national, that isn't the case. It has to be substantiated with extensive evidence. So if you are making a decision to put in an application on that basis, please ensure that you have everything in order to demonstrate the application that you're making, that it has to be genuine, and there has to be a conscious decision of people to live together in a subsisting relationship, a genuine subsisting relationship. Applications can and do get declined from people who are non-EA nationals that have married an EA national living in the UK, and the Home Office, after examining the application, have come to the conclusion that in fact it's not real, it's not genuine. That can sometimes happen because some people are not being honest, but in other cases it's a simple case of people not getting their paperwork in order, simply not putting in the correct paperwork, not putting in the correct evidence to demonstrate their relationship. Sometimes the circumstances are unique where there is a difficulty in people spending time together because of financial restrictions, because of long distance relationships and such. So although the relationship is genuine, their application can be harmed in failing to put things in place that would demonstrate that, and in particular to demonstrate the circumstances that are unique to their particular case, right? If any of this is affecting you, I'd like to hear from you. I'd be interested to know if you have been affected previously, or you feel concerned that you're going to be affected now that this decision has been taken. You can send us a WhatsApp message on 0788 55 99 786. This program is being brought to you by Khan Solicitors, and you're listening to Iman FM on 103.FM, best radio station in Sheffield, if you ask my opinion. And today we are building on the previous conversations we've had about people's right to enter the UK. And to recap what I said in the previous program, I broke down 3 categories of people coming into the UK. The first people that I defined were the people that had a right to abode, and those people are entitled to Section 1 of the Immigration Act 1971 to come into the UK without any let or hindrance. You've got a right to abode, you can come in, and as long as you can demonstrate who you are, you're entitled to come into the UK as many times as you like. Come and leave and re-enter the UK, no problems. Second category of people we talked about was people who are subjected to immigration rules and regulations. And we divided those 2 categories into visa nationals and non-visa nationals. These are people that require a fulfillment of UK immigration rules. They require those rules to be met by their personal circumstances in order to be given leave to enter the UK, basically being allowed to enter the UK and to be allowed to remain in the UK if they want to stay beyond the time that they're allocated initially. And the third category of people that we touched on were EA nationals. And this is a unique category of people. It's almost a hybrid category, in that EA nationals are nationals of their own country. Wherever they're living, they are nationals of those countries, but also they have been given the extra title of being citizens of the European Union that was established right under Article 20 of the Treaty on Functioning of the European Union, and that also includes us as British nationals. At the moment we are still, and we were, citizens of the UK, but we're also citizens of the European Union. And as members, as citizens of member states, we were entitled to travel, the right to move, reside, travel within the territory of member states. We were given the right to vote and stand as candidates of the European Parliament. And we were given the right to open up businesses, to gain employment in different member states. And what we are dealing with now is that the UK has taken a decision after the referendum that we all saw people voting on to leave the European Union. Article 50 was triggered 20th of March 2017 by our British Prime Minister, and a decision was taken to leave. Has that affected you in any way? I'm sure a lot of people are concerned that they will need to formalise their stay if they haven't done so already. Well, you have the opportunity to put in your thoughts, give us a call, and we can discuss your opinions. The hotline number is 0114 2425 200. The main concern people have is being separated from their family members. And if you're a non-EA national and you've come into the UK on the back of being related to someone who is an EA national, under normal circumstances, you would be subjected to UK immigration rules. So if you were to take away European law, you would then have to fulfill a completely different category of rules, right? In fact, if you are a family member of an EA national in the UK and you're travelling independently of your EA partner and you don't have the intention of coming to the UK to join them, then you are in fact required to meet the rules anyway. So as it stands, if you wanted to come to the UK, you had a husband or a wife or a civil partner in the UK, and you weren't going there to join them, you were just coming to the UK independently, then what the rules state is that you have to in fact meet UK immigration rules requirements. So if we take away the entire regulations of EU law, then by default, a large number of people that are non-EA nationals are going to have to go back to meeting UK immigration rules and regulations. Do you think that's going to make things more difficult for people? Or do you think it's going to make things more easier? My thoughts are that it's going to become more difficult for people to come into the UK because the avenues of entering the UK have suddenly narrowed. And that's going to make a significant difference to people who are either already here or are planning to come here. I'm pretty sure there are people that are EA nationals that are attempting to bring their partners over as we speak, and they're non-EA nationals. And they must be very concerned about what kind of timescale they've got in order to formalise all of this. I've heard it said by many people who are EA nationals, and it's been discussed in the mainstream news, about what is going to happen to people who are exercising their treaty rights once the UK has been withdrawn. Well, there have been some assurances being made by the government that people who are here exercising their right will not be forced to leave. It was a contentious issue that the Houses of Lords put their opinion into, right? But I think it's certainly something that will be addressed and needs to be addressed by the government. And you might be wondering, well, how's that going to how's that going to materialize? Well, part of the procedure of triggering Article 50 is that negotiations need to take place, and part of those negotiations, as well as being economic and political and legislative, will include the position of people that are living in the UK from EA national countries, but also conversely British nationals that are actually living in European countries who might be concerned that they're going to have to be forced to come back to the UK. Well, I doubt that we're going to get that kind of an extreme outcome, but I certainly think that the issue is going to be discussed. My suggestion would be that people need to take the initiative of dealing with formalizing their own status or the status of their family members that fall into those categories, seek legal advice and look at avenues that will help them to formalize their stay here in the UK. Although 2019 seems like a long way off, I think it would be very prudent for people to be engaged in the process now before things become set in concrete, if that makes any sense. To wait for things to be defined outside of what we have in place at the moment is to leave things in an ambiguous state. The advantage that Article 50 provides is mainly to the European member states as opposed to the state that's leaving, because it allows them to sit down and negotiate quite heavily the terms in which people or member state that's leaving will leave. And you might have seen in the news some discussions about an outstanding amount of money that is being demanded from the UK government to pay before the actual procedure is kicked into place, right? There's a lot of issues around money and finances that are outstanding. You're welcome to put your questions on WhatsApp at any time. If we pick up the messages in between today's show and next show, we'll try to address them on the next occasion. This show has been brought to you by Khan Solicitors, and it's been broadcast on Iman FM 103.FM. Our WhatsApp number is 07 8855 99786. Studio number is 0114 24 25 200. This is a regular slot between 4 and 5. If you have any questions, please send it through to us and we can discuss it in next week's show. I'm Shahid Hussain with Khan Solicitors. Thank you for spending your time with me.
Online at www.imanfm.com and on our app, you're listening to Iman FM.
ईमान रेडियो 103.1 FM के सुनने वालों की खिदमत में परवेज यूसुफ का मोदबाना सलाम। मैं आपके लिए एक खूबसूरत प्रोग्राम ला रहा हूं, चमनज़ारे गज़ल। एक यादगार प्रोग्राम सुनना ना भूलिएगा 103.1 ईमान FM।
For reliable, professional, and quality immigration services, Khan Solicitors, sponsorship visas, British citizenship, indefinite leave to remain applications, human rights, domestic violence, judicial reviews. You live your life. Let Khan Solicitors do the legal work for you.